2014, according to the Oregon Health Authority, 1,897 Oregonians took their lives that way. And colleagues, it's my hope today that this bill will help address that crisis. As this bill has advanced through the legislature, I think there's been some confusion, maybe misunderstanding about exactly what an extreme risk protection order is and how one obtains one. So I first want to lay out exactly the process of obtaining an ERPO. First, a law enforcement official or a family member is defined as current or former spouse, cohabitating couple, custodians, children, parent, sibling, or a person in a current or former dating relationship, would have to provide clear and convincing evidence under oath showing that the individual poses a risk to themselves or others. The hearing may be held without the person subject to the order at the hearing. This is an ex parte hearing, colleagues, and this happens in other states, and it happens in hearings when there's an emergency situation like a restraining order in this state. Next, the individual is served with the ERPO, which includes a notice to hand over firearms to law enforcement within 24 hours and a notice of a ban on firearms sale. There's also a summary of the evidence that was presented to justify the need for the order and a form requesting a hearing should the respondent wish to appeal. This kind of order, colleagues, is typically in effect for about 3 weeks. The individual who receives the order can then request a hearing within 30 days, and the hearing must be held within 21 days. This whole time, the burden remains on the family member or law enforcement to provide clear and convincing evidence showing that the individual poses a risk to themselves or others. A hearing can then be requested by either party to terminate the order early. The person filing the termination request has the burden of proving by clear and convincing evidence that the respondent is no longer at risk or will be in the future. Without early termination, the order expires in 1 year. The order can be renewed with new hearings when it expires, but colleagues, it goes through the initial hearing process again. And when the order is terminated, all rights are restored and property is returned. If an extension is sought, the burden is again on the family member or law enforcement seeking the order to prove the individual still poses a risk. The individual may present evidence in their defense at that hearing. Colleagues, a violation of the order is an A misdemeanor, but if an ERPO petition is filed as harassment or the statements given in court are false, that is also punishable by an A misdemeanor. I have heard through the course of this bill's progress that it's a violation of the Second Amendment, the right to bear arms. But colleagues, I want to assure you, similar long-standing laws in both Connecticut and Indiana have been challenged on Second Amendment grounds, and both have held up in court. In these cases, the court said that the states may restrict access to firearm by dangerous people if it's in the interest of public safety or an individual's welfare. In addition, the United States Supreme Court noted in the 2008 Heller case that the Second Amendment is not unlimited, and there are categories of people, such as people with felony convictions and people who have been adjudicated a mental defect or have been committed to a mental institution, that can be prohibited from owning firearms. In the event, colleagues, that the ERPO is issued and firearms are taken from the individual, those firearms may be stored by law enforcement, a federally licensed firearm dealer, or a neutral third party, or some combination